And of course, we're available to talk outside of this also.
Great. All right, KSTP is here, Star Tribune. Hi, everyone. Thank you for joining us. We're going to give it a few more minutes and let people make their way to the Zoom. Okay. Hello, everybody. Welcome and thank you for being here this afternoon. And a big welcome to our guests, Professor of Law Mike Steenson and Professor of Law Laura Hermer, who will be leading us in a fact check of Scott Jensen's recent TV ad and false claim that if governor of Minnesota, he would have no ability to impact abortion access in our state. Additionally, Professor Hermer and Professor Steenson will be walking us through various avenues that Scott Jensen would take to heavily restrict or ban abortion in Minnesota. There will be some time for questions at the end. And with that, I will turn it over to Professor Laura Hermer to begin the conference.
Hello, everyone. Thanks for being here. Yeah, so just regarding these claims, I mean, Scott Jensen has claimed that he has no ability to affect abortion rights in the state, that Doe v. Gomez is the law of the state. But the problem, of course, the problem is that he does have quite a lot of ability to impact abortion rights in the state. He is correct to the extent that he cannot himself, just on his own, amend the state constitution. But he can take all sorts of other actions. Of course, the governor is the chief executive in the state, has the primary duty of setting the policy of the state, public policy, including the policy toward reproductive rights and specifically abortion access in the state. And he has made it very clear on a multiple different fronts the sorts of policies that he plans to pursue. And one can find these on his website. He has a number of executive actions that he can take. Of course, he is able to sign legislation. He is able to propose, and he will propose, doubtless, if he were to become governor, he would propose legislation. He proposes budgets. As the governor, he has the ability to line item veto appropriations bills. So if a bill contains, for instance, funding for various reproductive rights, to the extent that he disagrees with that sort of funding, he can line item veto that. He can sign a proposed amendment to the Constitution into the law if, for example, we have a Republican controlled legislature. So there are a wide variety of ways that he can control this. He also will be appointing the heads of various administrative agencies, and he has the ultimate right of review for all administrative regulations in the state. I don't know if Mike wants to take over with the judicial avenues that he has.
Thanks, Laura. One of the major questions concerns the status of the Minnesota Supreme Court's opinion in Doe versus Gomez, which is a 1995 opinion issued by our Supreme Court. And in that case, the Supreme Court held that there is a fundamental right of a person to choose whether or not to have an abortion. All right. Now, keep in mind that that case was decided under the Minnesota Constitution, not the federal Constitution. So even though the Supreme Court of the United States has held that there is no fundamental right of a person to choose under the federal Constitution, there is a right to choose under the Minnesota Constitution. All right. Now, Dr. Jensen is absolutely correct when he says that he can't change that law. But as governor, he would have the opportunity to appoint justices to the Supreme Court of Minnesota. And the issue is whether or not a change in the composition of the court could lead to a change in Doe versus Gomez. So very bluntly, the question is, could Doe versus Gomez be overruled? And the question is absolutely. Justices have to retire from the Supreme Court at the age of 70. Justice G. Barry Anderson will be retiring soon. Now, of course, Governor Walz will have that appointment. But the composition of the court really does make a significant difference. And we don't have to really look any further than to the state of Iowa and what's happened there just in the last few years. In 2018, the Iowa Supreme Court held that there was a fundamental right of a person to choose whether or not to have an abortion under the Iowa Constitution. That's Planned Parenthood for the Great or for the Heartland versus Reynolds. Reynolds is Kim Reynolds, the governor of Iowa. In 2018, the Iowa Supreme Court said that there is a fundamental right to choose. All right. Well, in 2022, the Iowa Supreme Court said, well, there really is not. That decision that was issued in 2018 was just simply wrong. All right, so what could account for that difference? Well, Governor Reynolds had the opportunity to appoint 3 additional conservative justices to the Supreme Court of Iowa. They had different views about what this fundamental right to privacy is and whether or not it encompasses the right of a person to choose whether or not to have an abortion. So the point is this, with a number of appointments, and people leave the Minnesota Supreme Court all the time, sometimes for retirements. Some of the justices have been appointed federal judges. some of the justices leave for other reasons to go back, for example, into the practice of law. It's, I suppose, not really surprising that the composition of the court can change, and it can change fairly rapidly. All right, so what could happen is that with conservative appointments to the Supreme Court, the court might decide that Doe versus Gomez was wrongly decided. All right, now, I suppose in a way that sounds sort of crass, and as if we would just portray justices as nothing other than politicians wearing black robes. And I certainly wouldn't say that. The justices who serve on the Supreme Court of Minnesota are outstanding justices, jurists. They give very careful attention to the cases before them. Their opinions are well written, but they're nonetheless a product of their own basic ideology. And it's more likely than not that conservative justices are going to take a narrower view of what the Minnesota Constitution would provide. Now, I'm not suggesting that they would. And no one is a candidate for the Supreme Court of Minnesota would take a position on that issue in advance. But ideology matters, and we've seen that in the Supreme Court of the United States. So there, of course, the question is, what's different? Why was the Dobbs case so different than Roe versus Wade or Planned Parenthood versus Casey? Well, 6 conservative justices on the Supreme Court, I think pretty well explain it. And the simple point is the same thing could happen at the state level. So the governor really actually quite directly has an influence on status of abortion rights in Minnesota, not just abortion rights, but certainly for our purposes today, it has a significant impact, can have a significant impact on the status of those rights.
Thank you both. Are there any questions for either professor?
I have a question. I'm just curious. So it seems like you're saying essentially his claim that he can't really do anything because of constitutional protections is wrong. Not necessarily that. I mean, it seems like it would also be time. It would take a lot of time, right, to also change it. I mean, is that fair? Given all the things you mentioned, you'd have to change Supreme Court members. You'd have to, bring a case. It sounds like the central argument is that the governor can do things about it, but wouldn't it also be a time-consuming process? And it would take maybe a few years.
It potentially would take a number of years to change things to completely change things in the way that Iowa did, for example. But there are all sorts of very, much smaller things that add up pretty quickly that he can do in pretty short order. So, for example, when he if he were to become governor, if he appointed a head of human services and a head of the Department of Health, who were opposed to abortion rights, they could take a number of steps within the administrative agency to make it more difficult to obtain abortions and to reallocate funding from services that would provide, for instance, subsidized birth control or other services that might impact reproductive rights, and funnel those towards, for example, adoption services, which is something that he has said in his campaign that he wants to promote and fund more generously. So, of course, the legislature is going to determine how much each agency gets, but within that, the agency has a certain amount of discretion regarding how that money is spent. So he can certainly do those sorts of things. He could also take actions, try to build test cases, for example, in the care that he takes in upholding the laws. And so, for example, he may want to sort of slow walk funding through medical assistance of abortions or take other such steps. He might want, for example, as well, to rescind the executive order that that Governor Walz instituted, that was I think 22-16, regarding reproductive rights, and instead of having agencies coordinate to ensure that they're providing reproductive rights and care to the fullest extent of the law, something quite different could happen. Also, he could, for instance, allow the agencies to provide evidence to states that wanted to prosecute individuals in Minnesota for assisting people out of state in obtaining abortions or extraditing them.
And things can change quickly on the Supreme Court. There's only a 4-year gap between the two decisions in Iowa. And government does get to speak. Whoever happens to be in authority has a right to send whatever messages government chooses to send. And Professor Hermer mentioned Executive Order 2216. That's a government message about coordinating various departments to try to ensure that abortion services are going to be provided, and that Minnesota will not cooperate with other states seeking to prosecute people who utilized abortion services in Minnesota. That could change quite rapidly with the change in the governorship.
Great, thank you. I guess I'll ask another one if others aren't. Have you seen, in looking at what other states are doing, is it often through the executive branch that these actions are taken, or are these often led by, messages sent by the executive branch? Obviously, the legislatures have to pass these new laws that have been enacted, but I mean, have you seen in the states that are taking action a clear role of the executive and kind of a leadership on the executive side?
Yeah, so I think in Indiana, which I believe was the first state to enact an abortion ban post Dobbs, and that was just stayed today, by the way. In that state, Governor Holcomb had led the way, but of course he also has a Republican legislature, and so they were able to work in tandem in moving that forward. And then of course you see other things like in South Dakota, where Governor Noem had said that she was going to be quite bullish on restricting abortion access in a wide variety of ways. And of course they have a trigger ban that did go into effect. But after Dobbs came out and there was this strong backlash, she walked back some of those comments, sort of like you see Dr. Jensen walking back some of his comments.
Thank you.
Anything else?
Okay. Thank you all very much for joining us. Thank you, Professor Hermer, Professor Steenson. Please be in contact if you do have any follow-up questions. I'd be happy to connect you with either of our speakers. Thank you and have a great day.